So this is going to be a very, very exciting panel. With me up here is Professor Verchick and Bryan Sky Eagle. Professor Verchick is he literally wrote a textbook on disaster law. He is an expert in the field looking at it from a policy and theoretical perspective. And Bryan is one of the few attorneys that has had boots on the ground hours after a disaster in a major metro area, and he's an expert in the field when it comes to the actual practice of disaster law. So we're going to have both sides of the theoretical and the practical side here with us today. Where's the remote? Okay. This is Professor Robert Verchick. He is the Gaither St. Martin, I butchered that, Chair in Environmental Law at Loyola University. He's the Senior Fellow in Disaster Resilience Leadership at Tulane. Both of those are in New Orleans. He's the co-author of Disaster Law and Policy, the third edition, and he had just kicked off a book tour for his new book, The Octopus in the Parking Garage. And I want to take this moment to let you know, Professor, that is quality cover art. That the topic may be a little grim, but I'm glad you didn't cut corners on the cover art. Bryan Sky Eagle is a deputy chief and the resilience officer for the Houston Fire Department, one of the largest fire departments in the country. He's an affiliate legal scholar with the University of Houston Law Center. He co-authored the Texas Disaster Law Guide, and that is a publication that is found across the state of Texas, and everyone from counties to people in the governor's office. He's an area commander. He was the area commander for Hurricane Harvey with the city of Houston. Interesting note about Bryan, he had a successful trust and probate estates and probate practice in Houston until Hurricane Harvey, at which point in time he decided to get into the ever-changing field of disaster law. So we're going to be asking each panelist a question. They'll have a certain amount of time to give an answer, and then we will follow up letting the other panelists respond to that answer. And at the end of it, we'll have a Q&A. So if you have any questions for either of our panelists, please ask them. If you have a question for me, I'm begging you, please do not make me answer that with these two experts in the field, also on the panel. All right, question number one is going to go to Professor Verchick. Does a disaster declaration invoke legal duties that otherwise would not exist?
Thanks for the question, and thanks for having me. It's a lovely program. Does the Declaration create duties that don't exist? Well, one duty that becomes that crops up as a result of that is an obvious one, but one to keep in mind, which is the duty to protect life and property, and that essentially is when the disaster is declared, that's what the head of the state, the governor in most situations, is guaranteed or required to do. Now, sometimes there are duties that, if you think about it, either existed but now exist or have a different shape, right? So for instance, there's always a duty to provide due process if you're the governor or if you're members of a state, but all of a sudden when you have a declaration, when you've got armed officers sometime in the streets, right, during the aftermath of a flood or something like that, you've got some people who are just trying to find resources so that they can take care of their kids or eat or whatever. You've got other people who are perhaps stealing. You've got all kinds of things going on, and you've got to make sure that due process is followed, and in fact, even that your court systems are still working and available to do these kinds of things. A lot of what I'm talking about is kind of trauma that I survived during Hurricane Katrina, because all of that kind of went out the window, and we can talk more about in some cases why that is. But there's a duty to keep providing due process. It's not free-for-all, right? There's also duties related to standard laws that already exist, like anti-discrimination law and the law of disabilities and these kinds of things. We have a case coming up, actually, that a lot of us are watching out of San Antonio, in which plaintiffs alleged that that the state and the responders didn't take into consideration in their planning and then in their execution of their duties the fact that not everybody can successfully evacuate in place. For instance, if you don't have electricity and you rely on a ventilator or an electric wheelchair or something like this, or if you're 3 flights up without an elevator and somebody comes to get you in a Humvee and says, meet me on the corner, right? That doesn't always work. We found that in Hurricane Sandy too, where there would be crews that would go up to a brownstone and go up 3 flights, and there was somebody who wasn't able to walk, right? And so how do you get this person down? So those are arguably violations of anti-discrimination law, if that hasn't been something that you've planned before. Think about linguistic isolation, these other kinds of things. One of the questions is how much do we expect people to be prepared, that is, governments, to be prepared. There are also duties, and I'll just stop with this, that are related to other kinds of due process. For instance, during the COVID time, during that declared emergency and disaster, we had situations where some governors were alleging that they could accomplish quarantines. In Hurricane Katrina, we had one town alleging that it could block people from literally walking across a bridge into their jurisdiction. You can't do those things normally without some deeper kind of justification for it. In my neck of the woods down in New Orleans, every time we have an evacuation, the students in my clinic at Loyola are negotiating with ICE to make sure that people can get on public buses and get out of the city without having their identification checked and without having to be fearful that they might be jailed by trying to get on a bus, or that they might leave their home and their possessions and never be able to get back into the city without showing their identification. And as it happens, ICE every time says, oh, we promise we won't do that. And every time my students say, can you put that in writing? And every time they say no. And so these are the kinds of things that are duties, really, that we need to make sure about.
Thank you, Professor. I'm going to pass it over to Bryan at this moment and ask him for his response to Professor Verchick's answer to that, and specifically if he thinks any of the duties described by Professor Verchick change over time as the disaster progresses.
Sure. Speaking on that evacuation, one of the things we encounter is the Fourth Amendment right, and do you have that in an evacuated zone? We toss those over, and from my perspective in the practice, what he's talking about is policy. The governors and such will hand down suspension of laws, changing laws, and we have to scatter to make sense of that. It also, these declarations invoke a coordination effort and how we're going to coordinate these different jurisdictions that have their own competing authorities, which take a fight in itself about who's going to do what, who's responsible for what. Point in case is the San Antonio case, where certain obligations may have arisen under an emergency plan. Who's responsible for that? Responders, emergency managers, et cetera. But to that point, do they change? Absolutely. One of the things we're looking at is when the declaration has stopped, does that stop your duty? So taking the San Antonio case, is that now a moot case if the disaster has been undeclared? But from a practice side, a lot of it is working with agencies on the declaration of who's going to do what competing authorities do we have to work out, and how are we going to structure that? Does that answer your question?
Oh, yeah. Do you have anything else you'd like to add to that question?
No, I know we got on time, but I'm watching the time. And,
Okay.
and we'll go through it.
This question is also going to go to Professor Verchick. We know the national policies require the use of NIMS and ICS. Can you tell us about the policy, about those policies, and how it's practiced during the response phase of a disaster?
Well, I'm going to tell you about the policies very quickly, and then Bryan is going to tell you how it really works, okay? But this area of law, as you know, it's like filled with acronyms, right? So you got NIMS, right, which is National Incident Management System, and then you've got this ICS, which is a system below that on incident command, as they call it, incident command system. And NIMS is really a framework that was developed primarily, I guess, by federal actors, but with lots of input and cooperation from locals too, local levels of government and outside stakeholders. And the idea was to have some kind of a map, some kind of a framework for responding to an incident, right, which is a disaster we can think of, and but that where everybody knows what the rules are, they're using the same language, they have the same priorities. They're all speaking, if you will, the same language. And so that's established at the federal level, and every level of government and non-governmental actors, including schools and community groups and so on, can be trained in this way of thinking, in this way of acting, and organizing, so that when an EPA official meets with the governor, who meets with the head of an electric utility, who meets in the same room with an NGO, a nonprofit organization committed to helping the lives of immigrants who are in the community, that they are all talking in the same language, they understand what the priorities are, and they are familiar with the same way of responding, which isn't to say they're all going to agree, but at least they're all going to be on the same page in the sense of how things work. And then there's training that's involved where you can train up your organization so that everybody understands. So that's the textbook answer, but how it happens in real life, Bryan, is something that I'm sure is different.
You're right. Those are great in theory, but when we get out here in the practice of it, one thing that NIMS invokes is this idea of unified command. And unified command, from a legal perspective, we have to ask, what structure is that? Can it be sued? Can it sue? Is it a joint enterprise? How do these people act in this unified command, which is made up of different officials, different agency directors, as he said, he mentioned a few of them, government agents, private actors, nonprofits. And they come together and they're supposed to resolve what they're going to do. But each one comes with its own authority and what I call its own duty of loyalty. So if I have two counties beside each other and you're talking about resources, he has a duty of loyalty to protect the citizens of his county before this county. And so you're getting into the idea that, and I think that's why FEMA put in their structure, in the incident command system, the ICS structure, the idea of a legal advisor. And one of those, I thought this was interesting, that FEMA places an operations lawyer or a legal advisor in the command staff of your structure, of your ICS structure, to mediate disputes. I've never seen that in practice, but it exists on the FEMA's organizational chart as one of these things they put out of what we do. So at our level, what we're really doing is assigning or directing resources. We're collecting them and we're making decisions that will impact one community a different way than another community. What's not happening is how we measure that. And without measuring it, we see the inequities arise through the decision making. For instance, Winter Storm Uri this is just a quick sidebar, in that we had competing interests between two vulnerable communities. One was a hospital, and the first question we ask is it public or private hospital? And then we had a community on this end that needed rescues or assistance out of the area. And Winter Storm Uri in Texas had a cascading failure effect. Not only did you lose power, but you lost water. So the hospital asked the fire department to stop doing those rescues and those responses and use those water trucks to fill up our generators, because our generators that we're running on no longer had a water supply. So we got together and we discovered if we do this water shuttle, it's going to take me an hour to fill up, but that'll give you 4 hours of time to maintain your patients. So we brought the people together to find out how we're going to make decisions like this, because if we redirect resources over here, that's going to impact this community over here. That's the decision making that goes on in the unified command. How do we resolve that? And so it's hard to look back upon it and say, how do you measure that? Was that the right call? Of course, the hospital is a target hazard. When you do your hazard mitigation, you identify those things. But also the community also has a right to get the resources they're paying for. So that's just was a sidebar. But in practice, I think the other speaker brought up Web EOC, and it creates this common operating picture. So I go down just one level low, and we call it situational awareness. And what that means is who's doing what. It's pure chaos almost. That you're in this emergency operations center or command post, you have many different actors, different players with competing authorities and duties, and then you're trying to understand who's doing what. But when you don't know what this decision impacts that decisions until after, post-incident, do you realize the inequities. So part of this panel, part of what we do is in my legal side of it, is to address how do we measure situational awareness to where we can, because if you mitigate the inequities on the response side, it will mitigate the needed inequities in the recovery side.
Bryan, I have a quick question about that. When you were, when you saw those leaders there talking about how to dispense of water, right, how to allocate it, did anyone mention legal liability? Is that something that people are concerned with even as they're in this chaos trying to make decisions?
Well, if you ask an emergency manager, that's their number one priority, because somehow those decisions always get pushed down to the guy in the emergency operations center, not the elected officials. So that's when you get a bunch of lawyers in the room. And we're talking about who's going to make the call, who's going to fall on the sword for this if it turns out to be the wrong one. So some agencies enjoy immunity, but then immunity is not absolute. You get into ultravirus, if we're in a law school, and that old theory about ultravirus, it's a real thing when you're out here practicing. Did you have authority to make that call? Did you exceed that authority? Did you step on him without his authority? So those things have to be walked in parallel, decide what this is going to look like for all parties. The elected officials in the room, yes, they're worried about
They're worried about that too. They're worried about their constituents too,
That's
what
right.
they're going to say at the end of the day.
Real quick, just a quick question to follow up on this for both of you. In your opinion, for operational attorneys that roll within ICS, who is the client for that attorney?
I'm going to send that to you.
Yeah, I've asked this a dozen times. I get one answer from the bar, one answer from the law schools, one answer from the practitioners. It's an unresolved issue. And to give a little bit more context, what I do is, let's say that you have a mayor there, and he has his city legal team with him. But you also have the city services, the police, fire, public works. So when your emergency managers or people like that happen to make these decisions, want legal advice, the attorneys simply say, you're not my client, the mayor's my client. Or is she? Because she represents the city. So those resources that the city provides, do they not fall under that attorney-client privilege as well? That's an unresolved, and I'm interested if anybody else here has ran across that. Because it really puts a chilling effect on working together. That's what happens. The conversations slow down and stop if we're deciding who the client is. And that's one impediment to the unified command, which NIMS requires. So if you want to get reimbursement from FEMA, you do have to adopt NIMS. NIMS requires you to set up a unified command. In there, it requires you to work together, but it doesn't account for legal clients in that context.
Professor, do you have anything you want to?
No, I think that's the state of where it is, yeah.
All right.
Good research project.
Yeah, it is, that's right.
Quick show of hands. Are there any law students in the room? Free advice, take it for what it's worth. You can take the NIMS and ICS courses on FEMA's website. Not only are they a requirement for a lot of federal jobs, they're also a requirement for a lot of state and local positions as well. And you'll learn the nomenclature and the phrases that pay in job interviews through that. So just a heads up, I can't guarantee that they're always the most engaging presentations, but it gives you some language to use in a job interview. All right, question number 3, this is going to go to Bryan. Staying with the response phase of a disaster, how is the rule of law applied and upheld in a disaster?
You know, this is where Texas and Florida have a lot in common with firearms. Because I say, if it's 7 days that you get to work, carry an open firearm without a permit, that pretty much is the law, or whatever they're going to say it is at that time when you're out in the field. But in there, you're under a different environment. You don't have time to do the legal research when they ask you things. There's probably no facility to do that. Good luck on you're setting up your communications as far as getting into your databases to research things. So how do you uphold the rule of law? That operations lawyer, that legal advisor there, he has to stockpile policies and rules just as other services would stockpile food and water. The time and the operating environment just doesn't allow for a traditional setting. And just take, for example, an operations lawyer that's asked about civil rights. And how do you, in the San Antonio case, there's a lot to do that. I'm not saying they're a civil rights specialist, but you're going to get an operations lawyer there that's going to ask about civil rights. So from that, they don't have the time or the environment to go look on their case law. You're just going to have to know it there or not to be able to give them a response. And in that analysis, when he's doing that, or she's doing that, in the response area, you're looking at how these assets are being distributed and what impacts what communities. When Hurricane Harvey came, we had different claims afterwards about who got votes and who didn't get votes. That's a real life example of how people feel the inequity between the services that they're expecting to come. Another idea is when we talk about authorities, I brought up the ultra virus, but how does that play out in holding up your obligations while you're responding? What is that operation lawyer's going to do? I know with the other gentleman who was in the National Guard, the Department of Defense has I think it's the law of war. So they send out these lawyers out there to teach them the rules of engagement or show those commanders out there the rules of engagement. FEMA has something very similar. It's the disaster operations legal manuals, but they really represent FEMA. They're trying to help you clear some of the log jams with FEMA. On a county level or local level, it's hard to say because you may get a guy from contracts that are just thrown into your EOC now to say, handle the questions. So the rule of law is upheld really by that attorney in the room who is looking at, when you're in the response phase, of how these assets are being distributed. So if you don't have it, so here's another thing about unified command and how it plays on the rule of law. We have these agreements in place, memos of understanding, mutual aid agreements. Unfortunately, they're not quite binding. So if you create plans based on these resources that they promised you, they still have a duty of loyalty to their own community where they may not provide those resources for you. If they don't provide the resources, you can't fulfill the obligations. So this is the things we talk about, how we're going to get those things. So it's upheld by that lawyer in the room, guiding the process, putting up the guardrails, things like that. Professor?
Well, I'll just say, well, since I teach at a law school and since we have law students, I'll have to say this one thing, and the students are going to sound great at cocktail parties. This issue about rule of law and disasters goes at least back to John Locke, who wrote a whole piece about this, right? About when can rulers sort of take over a little bit when there's a disaster. One thing that has always struck me that I think is interesting for our group today is that our concept of how disasters work in the United States and how people react influence what we think we can do without in terms of rule of law during a disaster. So for instance, there are a number of myths about disasters that we know are empirically untrue. Now they might be true in a particular situation, but usually they're not. And one of those is that people tend to be violent, or they tend not to follow law during a disaster, all the looting, all of this kind of thing. That is empirically untrue in the United States. But when we saw Hurricane Katrina and afterwards, the deployment of the National Guard and others often takes on more of a paramilitary flavor than I think it needs to. So for instance, one of the things that kept President Bush that encouraged him to delay inserting troops into New Orleans during Katrina was his belief that they weren't armed enough and that they were literally waiting for more firearms, right, in order to do battle with the people who were violating the law in New Orleans. That's that whole mentality just isn't right. And it slows us down, and it keeps us from doing things that we might otherwise be able to do. And so, for instance, afterwards, when some states were rethinking about laws that they should have, one of the laws that came up again and again was stand your ground laws. That like, oh, well, that's how we're going to respond to disasters the next time, is have a better stand your ground law. When you might imagine that if you had a little bit of political power and leverage, you might have used that for something different if you had a different mentality about what was actually needed. So that's one idea about rule of law, what's needed, what's not. I'm also concerned, and I'll just throw this out there without having perhaps the time to develop it more, but in my mind, one idea about rule of law is making people whole after problems have occurred. And we have on the books statutes that immunize certain entities from any kind of responsibility. In Hurricane Katrina, it was the Army Corps of Engineers that misdesigned levees that failed when they shouldn't have. And yet it never had any liability because of something called the Flood Control Act, which insulated it from any liability. In the Deepwater Horizon blowout, the statutory laws that control liability there are limited to $140 million, period, right? And so what happened is the president jawboned Deepwater Horizon and BP to basically waive that limit, but that limit's still on the books, and there were attempts to roll it back, and they failed. And so part of the way I see the rule of law is when we develop laws that insulate parties from liability that, legally speaking, they would normally bear. And that creates a kind of a moral hazard. That is, it reduces incentives to behave in ways that are safe.
We have just a little bit of time banked up, and I wanted to throw this out to the panel. What can local jurisdictions do, county, parish, city, what can they do in the mitigation and preparedness phase of emergency management to lessen the strain on the rule of law that happens hours and days after a disaster? Either one.
Think ahead. And that's something that I'm happy to say after actually after 9/11, after Hurricane Katrina, maybe after the pandemic, the high of the pandemic, we're starting to see, every time one of these things happens, we start to see people thinking ahead saying, oh, well, that thing that we used to say is unprecedented isn't going to be unprecedented when it happens again. And so, for instance, in New Orleans, we completely redid, well, you know, the school system, the prison systems, and the court systems. My dean, Madeline Landrieu, was a judge, an appellate judge a state judge during Hurricane Katrina, and it was just amazing to be. There was no plan to get judges hearing cases or hearings, right? So they could grant orders and these sorts of things. And so just knowing that those things are going to happen, if you don't have courts and you don't have court officials, you don't have rule of law, right? When you need to get instant decisions about particular things. I think also that community groups can think about these things early too. So we have in New Orleans, we have a group called the Evacueteers, which is a wonderful group, and it's an NGO. They go out, they adopt neighborhoods and communities, and they send folks out during normal time just to get to know all the neighbors, right? Who's disabled? Who doesn't have a car? Who doesn't speak English? All of these things develop trust, and then later on, when there are problems, these folks go out into the field and develop these ideas. We have a group called the Cajun Navy, formed by Honore, who basically has done the same thing. You know, getting civil society, if you will, sort of people on call, volunteering, who can pull people into boats, pull dogs into boats. Get to people on their rooftops in a submerged situation when nobody else can. The first responders are always the people who live in the community, and so we all have to understand that these things are not unprecedented. They're just things that don't happen very often, and it's easy to forget. And when newcomers move into a place and they don't know, they need to be educated by other people who live in those communities.
I think you just said something very, very important that I think you hit the nail on the head when you said it's not unprecedented, it just doesn't happen very often. And that's something that I think members of the community and people who are not first responders or in the emergency management field, they need to understand that distinction is that it is precedented. It just doesn't happen very often. So you need to think about what you're going to do.
So to add on to that, that's the paradox of a response phase. If you put your focus toward preparedness and they feel safer, ironically, people take more risky behavior. So when you're creating resiliency policies and things like that, we're getting into evacuations. We had the Cajun Navy come to
Right.
Harvey. Some were jam up. Some wanted to sign the bills before they act. This is another thing we deal out there is, did the county judge ask you out here, or did the mayor ask you out here, and who do you work for? But real quickly, to parallel on the immunity, there's this defense concept called, the act of God. Mm-hmm. And probably on the next question, I'll get to the Arkema case. In Houston, we're a big petrochemical. But after that, to the mitigation, we did revamp how we identify and engage with our petrochemical industry. Here recently, after Winter Storm Uri, now we're revamping how we identify and register the people in our vulnerable communities. But that goes into its resilience strategy.
Thank you for that leeway, Bryan. Question number 4 is going to go to you. How are resilience policies applied to public safety agencies?
So for us, we're considered community lifelines. Our resilience strategy is a little bit different from a private practice. We have to stay in service. We have to keep these things open. Obviously, hardening your institutions will allow that to do that. To identify inequities, you're going to have to put your focus towards strategies, identifying situational awareness, so we know what's happening and we can make better decisions. And then your public and private partnerships. And this is what I want to get into about the Arkema case. I don't know if you're familiar with that, but during Hurricane Harvey, a couple of things happened. And this goes into the act of God defense. This was the first time in Harris County that they brought criminal charges against a company for negligence. They didn't prepare enough, you could say. Real quickly, in that case, they had dangerous chemicals left in a trailer. Hurricane comes, it floods. They were monitoring the temperatures from a remote site. Of course, that fails on some level. It leaks. This is probably pretty timely with the East Palestine case, where there's a plume released. Hurricane passes, you get many calls for respiratory distress in this certain area. One problem with the Unified Command is they're not in the room with us. How do we know what they have? They're not communicating with us. So what do? We respond to those distress calls for respiratory complications. They set up a perimeter to try to identify the plume, and then they send in ambulances to go, pick up the people that are calling. Unbeknownst to them, they were also now exposed to this chemical. Later on, after it's all over, it became a detonation site. I think they're just going to detonate it to get rid of it. But what we learned was when that response phase, not having these people in the room, not even knowing how we're going to communicate with them during the response of these things, we've lost 15 police officers and about 11 EMTs that now have to go to the hospital themselves. So the district attorney said, hey, that's assault, right? You've known about this plume, you released it, you didn't contact these agencies, we send first responders in there, they get exposed, they go to the hospital. And they should have. So if you follow the case, if I remember it correctly, one of the defenses was raised was act of God. They didn't cause that, there was no intention on that, maybe the case was brought for political reasons. They were later acquitted, but you still lost those first responders out there for 2 weeks until they recovered. So we didn't have that resource. And more importantly, where are they at? If you haven't done your threat hazard mitigation plans and identifying who these people are, how do you communicate with them? We didn't know they were monitoring these things off site. We didn't know there was a plume released during the hurricane, which felt the effects once it passed and the winds have calmed down and it started settling in on the community. So the DA made a statement in one way to say, hey, is that criminal negligence or is it an act of God? And this is one thing we toss around quite a bit. Where is that line? That's another unresolved deal. If you look at the CERCLA cases, the Clean Water Act, things like that all have a provision there. If you're private contracts, it's the force majeure clause. But at some point, when does the responsibility take place? In the Arkema case, it drew a bright line to say that these type of chemicals are dangerous. So these type of chemicals, knowing it could impact a huge swath of that community, is one of those things we'll take more serious than others, and started re-identifying how they're doing their hazard mitigation plans. As far as other resiliency policies, we deal with situational awareness. I know some call it the common operating picture, but without that, if we don't know how these decisions are being impacted, we don't know how to make the adjustments. And that's going to cause consequences on the recovery side. If you take the hospital case, if you take the Cajun Navies, there were some people that got votes, some people that didn't. And we had every agency there. We had military, we had FEMA, we had the Utah group, which is a group of people that volunteer. And then you had the nonprofits. Now, one of the things we talked about as far as a legal perspective is something similar to what the fire service does, and it has to do with trust. So if you're in the wildland fires in California, they change out people all the time for shifts. But you have to be credentialed, or they have to know that you know what you're doing before we'll work with you. So they have a red card program. They call it a red card program. And what that does is it shows his credentials saying, hey, I'm an incident commander, I know what I'm doing. The same thing applies in a command post, in an emergency operations center, where if you're going to change out these people, let's say attorneys, these operational lawyers, I know in my city they can throw any lawyer in there. They come from the airport, they come from contracts, they come from all over and just say, hey, this is your thing now. So we were talking about doing a mutual aid or something like that as far as resiliency, is to build up a credentialing program. So when you do change these people out, the actors, the commanders, the elected officials, all those people know that this person has some training and credentials in this area of disaster.
Thank you, Bryan. I'm going to turn it over to Professor Verchick. Do you have what is your response to Bryan's answer to that?
Well, one of the things that occurs to me about this, because I think all of this is like dead on, is I'm always trying to think about what do you do ahead of time so you don't have these problems, right? So you don't have somebody who's hurt someone and then you have to ask whether that's an act of God or something that you're really responsible for. And for you law students in the room and you lawyers in the room, when things are calm and you're wondering, oh, what could I be doing, right? One of the things that you might think about is lobbying for or advocating for resilience measures that keep bad things from happening. So, for instance, all of these facilities that have toxic substances are controlled by something called the Resource Conservation and Recovery Act. And it is true, right, that they have duties when there are spills, but they also have duties before there are spills. Specifically, they have a duty to have proper flood management plans and hazard mitigation plans. Right now, there are several courts that are deciding whether or not those have to incorporate explicitly climate change projections because flooding is changing, right? And so what do you have to be prepared for? You know you're going to have an emergency release when a hurricane comes, right? A flare of some kind. It's not unprecedented. It's not an accident. It's something you can plan for, right? And so actually I contributed to a white paper with the Center for Progressive Reform, as progressivereform.org, and we had a white paper that was called Double Disaster. And what we were saying is there's always a second disaster when you're talking about these chemicals and so on. And everybody knows they happen. And the problem is we don't know what chemicals are there. We don't know what their mitigation plan says. People in the community don't have enough information about what's being stored there. Why are all of those things true? Because there's no regulation requiring it. When we had that, the train that jumped its rails in East Palestine, EPA officials are there. They don't know what's in the cars immediately. Why? Because there's no requirement that the contents be publicly available because of the size of the train and some other things, right? So that is something that should change. When all of the firefighting water, which was contaminated, was then recovered and sent for disposal, it originally was going down to the Houston area. And the governor of Texas had a fit. He's like, I didn't know this was coming into my state. Why didn't he know? Because there's no rule that requires him to know or anyone to ask any kind of permission. And it was settled otherwise. What I understand is all that water is now being disposed of in Ohio. But the point is, why should these arguments and disputes have to be resolved immediately? Why can't we think about passing some of these regulations? And the point isn't that no one thought of them. The point is they were resisted and no one was advocating for them. And so that's one thing that I would just put out there.
Thank you, and can confirm I would categorize that as a fit was thrown. All right, last question. This is going to go to you, Professor. What are some disaster resiliency policies every community can implement, and are they the same or different as climate resiliency policies?
I'll get to the second one in my keynote because that's what it's all about. But I think that certainly every community has a hazard mitigation plan of some, or almost every. I mean, there are thousands, tens of thousands of these hazard mitigation plans. The problem with them is they're often too vague, and I'm speaking generally, that many of them are too vague, and that many of them are cookie cutter because the communities don't have the resources to write them themselves, so they get a consultant who's written a whole bunch that have been successful. The problem with that is it doesn't really rely on an explicit assessment and inventory that the communities themselves have done. And spoiler alert, they don't include often climate projections or things that are created about climate specifically. And that's important because climate really is going to make things unprecedented. And we have information on how to do it, on how to project into the future. But if we don't do it, we just rely on the past, and that's a recipe for disaster. That's a problem, I think, with what we saw in Hurricane Harvey and what we saw with Hurricane Katrina and Hurricane Maria in Puerto Rico, is that we're not thinking about what it's going to be like in the future. Some states do. In Maine, right now, there is a law that just passed that requires electric utilities in Maine to come up with forward-looking plans that incorporate climate change and that explicitly incorporate issues that vulnerable communities will face. Those things have to be in the plan. If they're not, it goes back to the drawing board. Why do we have a law that says that? Because we have a lot of hardworking advocates that pushed and pushed and pushed to get it through. And that's the kind of changes I think that communities need to be taking on.
Bryan, what is your...
I want to pick up where Professor talks about, I want to try to put this in context of how we view it. If you'll think back to the Paradise, California wildfires, right around the same time, they had an explosion on a boat. Killed 10 people, the NTSB showed up, investigated the cause, the response, measured things, and issued a report in 10 days. The Paradise wildland fires killed 85 people. In a year after that, there was still no report on what happened. And so what I'm getting to is no one's measuring the response. No one's seeing if this is effective. There are many complaints of why one community got the notices, the fire trucks with the sirens telling them to get out. There's another community that never heard of that, causing them to stay in place. And that's where you see a lot of the deaths. But pick it up on the climate change. Similar, we don't have an administrative law body that would go out into these response and say, what was the response like? Was it climate contributed, that the conditions were right for this? If they were, why wasn't the community notified? We don't have that body in place like the Chemical Safety Board. They'll come out, these explosions, what was the chemical, and then what was the response? So these kind of issues are highlighted in a response phase to me, that they shine a light on it and say, how do we, so to answer the question about resiliency policies is, at what point do we start measuring our response to see if it's effective and get those answers that the professor's talking about is, what were the conditions that set this off? So we learn from that. That's not happening. And we take this whack-a-mole approach, right? It's out there, you shoot all the resources over there until it goes out, and then you go back. And then in the Paradise, when that happens, there's a whole community that gets disregarded, and they end up stranded. Which is another resiliency policy about the CERT program, the Community Emergency Response Teams. That's a big thing in the community because sometimes there is no response coming. Like Professor talked about, you're gonna have to do for yourself to get out there in the community and train how you do that.
Thank you, and I'm gonna interject one policy that I think every state should implement. It's very specific, but it can go a long way, is that have a model debris removal contract drafted and by whoever's doing your procurement statewide or whoever's doing your emergency management statewide, and do a model cookie cutter contract for debris removal. It handles all of the liability issues. We have it in Texas, and we have seen Harris County, which is one of the largest counties in the country, use it, as well as a city in a town in Far East Texas that has 82 people. And they can go to the same website, download it, put in the information, sign it, and then debris is starting to be removed immediately. It saves time, resources, effort, and energy. So, my 2 cents.
Good.
All right, questions for the panelists? Actually, while they're tracking down questions, Professor, when is your book coming out?
Oh, I'm so happy you asked. I have a book coming out on climate resilience called Octopus in the Parking Garage, and it is available in the back. And we actually have some copies for sale after the keynote or during your lovely lunch.
All right. Any questions for the panel?
I think she had her hand up over there. Where is it?
Oh, she's there.
Hi there. So I'm starting to explore if and how force majeure may come into play with some of the mortgage and other breach of contract cases I've got with flood survivors in Eastern Kentucky. Do you have any experience or thoughts of if acts of God is a relevant thing for me to pursue and keep looking into?
You want to take that with me? I think there is a trend, and I don't know the law in Kentucky very well, but there's definitely a trend for force majeure acts of God to be more and more limited in the court's mind. In other words, because we know that storms happen, wildfires happen, and these kinds of things. So it almost has to be something more unusual in circumstances than that.
I think,
Did I get that right?
yeah. The position I look at is how detailed is it, right? When you say act of God, you say hurricane, you're going to have to start detailing what in that hurricane are you referring to. Is it wind damage? Is it flood damage? What in there? So you have to drill it down to get more of a detail to make that, I think, more appropriate to be in there. So is it relevant? Is it relevant to private contracts? Absolutely. They're going to want that defense, and some things are beyond their control. But also there's a certain point where we have to identify it. I went through some mediations and some arbitrations, and there's always this fight about what we're going to agree to, about how granular we're going to get to control this arbitrator so he don't go off the rails and pull in something we didn't anticipate to make his ruling. I think something similar to that exists here, where you got to get with that mortgage company, the two sides of that contract have got to drill down that force majeure clause so one side or the other doesn't go off the rails as far as making a claim or setting a defense.
Great question.
Both of you mentioned there's not an effective way to measure response and the effects. There are after-action reports as a standard procedure. Do you think there's a method? Do you feel like those stay too local, or is there a method to incorporate after-action reports and the follow-up that goes through that into a wider policy-making effort?
Well, I think Rob touched on it, the professor touched on it when he said there's no regulation. So that AAR may end up on the shelf. It's nice to know, but what are you going to implement? What lesson are you learning that's going to come down to money, of what this is going to cost to correct it? It's good to know. You can change your practices on it. But as far as implementation to change your policies and how you respond, that's a different question. And I think right now it just lands on a local level and go up from there of how committed they are to measuring response.
And it can be measured, and in fact, we do it at the Tulane Disaster Resilience Leadership Academy, and also recoveries too, obviously. The trouble is that it costs money, of course, and funding, and that people rarely, in my experience in government, want to spend resources on evaluating how they did. They'd rather spend resources on doing something new, and there are obviously reasons for that, but they're not justifiable, in my opinion.
Gonna sing a little different tune than what you just heard. I think the after-action reports do get looked at. They don't always get put on the shelves. They do look at it, but they're always going to look at it from a monetary and a fiscal point of view. And then you get into, well, how do we measure equity and discrimination? Mm-hmm. And then that's when the differences of opinions and can of worms get open. And I think a lot of policymakers think it's easier just to say it, and then move along without making any, mandating any changes.
Good morning, Letitia Jones, Mercer Law School. So I have a question. Do you think as we see these NGOs, mutual aid associations crossing over state lines, that we're going to have to push for broader Good Samaritan laws? Because we saw Cajun Navy was stopped at the border in Texas. We see where a lot of the state bars are no longer allowing lawyers to come in immediately after a disaster. Do you think we're going to have to advocate for resiliency for Good Samaritan laws?
It's a really interesting question, right? Because part of this is it's a tension between rule of law, as traditionally sort of understood, and trying to get stuff done, right, in Good Samaritan laws. I guess I lean toward the Good Samaritan laws, and so I'd be in favor, in general, of what you're proposing. And I actually do think that it's a barrier in some cases. So if you want to see more of that kind of work, then I think you're right about that, and I would support you.
One of the things we encountered when we receive these incoming organizations, some spontaneous volunteer things pop up, is that we struggle with, if you come under my command and I'm directing you to do something, are you now an agent of the state, right? Sometimes they don't want to be. Sometimes we need them to be. Otherwise, they can do what they want, right? And we don't have control over that. So you bring up an interesting tension between what does the state who's trying to manage the response versus what does that NGO or does that volunteer actually want to do. And now, and when I encountered them, I was thinking I never had a Navy in Texas, but I think they did at one time, which was payment, right? There's certain things that go with that. Not everything's a straight volunteer, although they are volunteering their services, but then that goes in who asked you to be here and what's the expectations. Something is the red card. I think that gets into licensing, like you said, about attorneys, nurses, medical practitioners. There's this tension between just letting anybody in under Good Samaritan versus putting them into a shelter to let them operate with people that looks more like state action than volunteer.
And they're exposing themselves to danger too. Absolutely. In some cases, and they may not know the extent of the danger they're being exposed to in talking about contaminants or things like that. Yeah.
Great question.
Hi, I'm Ariel Dashow. I'm a student here at Stetson Law, and something that I've been wondering since you all have been talking is how do you think local and state policymakers can address some of these more slow burn climate issues that are exacerbated by our increase in natural disasters within the political and policy needs of the more immediate responses?
Go ahead, Professor.
Yeah, I'm going to kick that one
To
raw.
make sure I understood, you said slow onset disasters are what you're interested in?
Yeah, the slow
like
onset,
drought?
like issues like sea level rise, overall climate increase, stuff like that.
Yeah. So these slow onset sea level rise, drought, thawing permafrost might be another one. These are really difficult because you can't always. The law's a little unclear to what point you could declare a disaster based on some of these things. Drought is explicit, but the other ones aren't, although I think there's quite a bit of latitude that a president would have in those cases. But be that as it may, it's hard because you don't always know when you're in the middle of a drought until you're almost out of a drought sometimes. It's like a recession. You have to look backwards and do the numbers, right? And so I think the way to do it is to plan as if you're always on the edge of one or in one, particularly with drought and water scarcity. We're talking about allocating water or building on the coast in a particular way. I think you should be looking long term and saying, well, what is that going to look like in 50 years? What's that going to look like in 100 years? If it's not going to look good, I'm not going to let you build, right? And that's hard, and there's more to say, but that's where I'd start.
I'm going to jump in and I think get the last word in here. It goes back to the last two questions. One thing that I would like to see happen, and a lot of these issues can be addressed, is if there was a consolidated approach to policy changes post-disaster at the state legislative level. Mm-hmm. Take Winter Storm Uri for instance. There was every group in the state of Texas came in and they said, we have this policy that we want changed. Sometimes they were similar, sometimes they were totally different. So when you give a legislative body, let's make the number easy, 100 potential policy changes, and they enact 20, they're going to pat themselves on the back and wait and not going to do anything until the next not unprecedented natural disaster occurs. So I think that's a way to get some of these issues fixed.
All right, thank you so much to our panelists. We will hear more from Professor Verchick during our keynote during lunch, which is now. So if you all will please head straight across to the Man Lounge, grab yourself some food, and come back and get situated here. We'll probably kick off in about 20 minutes.
Good stuff.